everybody. Happy MTSU Constitution Day today. We're 3 days late, but welcome to it, and it's our annual celebration, and everybody please give welcome to our University Provost, Dr. Mark Burns.
Well, thank you, Mary. On behalf of Dr. Sidney McPhee, our president, and really everybody at the university, welcome to this event, which, as Dr. Evans said, is part of our annual celebration of Constitution Day. MTSU has been doing this for more than 10 years, and we've had a whole variety of programs over the years. And in recent years, we've included the reading of the Constitution at various places around campus. And that's, I think they're mainly over for today, but that's a great thing. And today's panel, of course, is filled with very prominent folks who will be introduced later. But thank you all on behalf of the university for coming. And that's really it. I'm here to welcome you and say thank you to Dr. Evans, who's really the driving force behind this, and enjoy the presentation. Mary?
Just in briefest overview, I want to be sure and let everybody know that Constitution Day, technically speaking, and from 1787, is September 17th this year and every year. It should be one of those dates that stays as current in your brain as does July 4th, and we are lucky enough next year in 2018 that September 17th actually falls on a school day. So we will be celebrating in 2018 on Monday of next year. As Dr. Burns said, we've been celebrating Constitution Day really effectively for the last 12 years, since 2005 at MTSU, and we have been pleased to capture it as a teachable moment because we are firmly committed to the idea of civic learning across the disciplines. We understand that every single solitary one of us is a citizen of this country, and we graduate as citizens going back to our home communities. We want civic learning to be pervasive, not partial, across our university, and central, not peripheral, to our identity. And we also believe that if, at the very least, taking a day, and it should be many more than this, to talk about we the people, to talk about how we go about establishing justice in this country, ensuring domestic tranquility, and forming a more perfect union. These are challenges that each of us as citizens faces every day, and that challenge never goes away. We are charged to do it, and we are often remiss in giving the proper credibility and honor to the judiciary branch, which is so important and certainly was perhaps exceedingly pivotal in the outcome of this past fall's election a year ago. So to help us learn more about the judiciary today, we have these 5 esteemed federal and state judges, and Dean John Weil of the University Honors College will introduce them.
At the same time he was working on the Declaration of Independence, Thomas Jefferson wrote a letter to his former law professor, George Wythe, in which he observed that the dignity and stability of government in all its branches depends so much on an upright and skillful administration of justice that the judicial power ought to be distinct from both the legislative and executive and independent of both, so that it may be a check upon both, as both should be checks upon that. Today we have a distinguished panel to discuss the constitutional role of an independent judiciary. In making the introductions, I feel a bit like President John Kennedy, who, when hosting a group of Nobel laureates at the White House, observed that there had never been a more auspicious gathering there, except with the possibility of those occasions when Mr. Jefferson was dining alone. Your program includes detailed descriptions of each of the guests, so I'm only going to cite the highlights, beginning with Judge Curtis Collier and ending with our moderator, Mr. Keel Hunt. Judge Curtis Collier is a graduate of TSU and of Duke University. He spent 5 years in the Air Force before serving as an assistant U.S. attorney both in Louisiana and in Tennessee, and as a U.S. district judge in East Tennessee. Now, on senior status, he has received the American Inns of Court Professionalism Award and helped found an Inn of Court in Chattanooga. Judge Martha Craig Daughtry is a Phi Beta Kappa graduate of Vanderbilt, where she is also a member of the Order of the Coif. She was the first female assistant U.S. attorney in Middle Tennessee, the first woman on the Tennessee Court of Criminal Appeals and the Tennessee Supreme Court, and is now a member of the U.S. Sixth Circuit Court of Appeals. She has taught at Vanderbilt and at the Appellate Judges Seminar at NYU, and is a member of the Judges Journal Editors Board and of the American Judicature Society. Judge Alberto Gonzalez is a graduate of Rice and Harvard University, served as Attorney General under President George W. Bush. He has been a justice on the Texas Supreme Court, served as Texas Secretary of State, was counsel to the U.S. President, and is now Dean of the Law School at Belmont University. Recently authored True Faith and Allegiance, The Story of Service and Sacrifice in War and Peace. And I'm sure he will not object if I hold it up and let you know that there are copies for sale there in the lobby. Judge Gary Wade is a graduate of the University of Tennessee. He served on the Tennessee Court of Criminal Appeals and on the Tennessee Supreme Court, where he was Chief Justice from 2012 to 2014. He has received numerous awards, has served as president of the Tennessee Judicial Conference, and is currently dean of the Lincoln Memorial University Duncan School of Law. Judge Penny White has earned degrees from ETSU, the University of Tennessee, and Georgetown University. After working as a solo practitioner, she became the first female to serve as a circuit judge in the 1st Judicial District, the second woman to serve on the Tennessee Court of Criminal Appeals and the Tennessee Supreme Court. She is currently a law professor at the University of Tennessee and has published numerous articles in law journals and received many awards for outstanding teaching. Our moderator for today's forum is Mr. Keel Hunt, an MTSU graduate who also has a master's in journalism from Northwestern University, a longtime writer and city editor for the Tennessean. He served as special assistant to Governor Lamar Alexander and is a member, I'm proud to say, of the Honors Board of Visitors at MTSU. He is engaged in numerous public service activities, and I did not buy another copy of his book, which I have at home, but his book, Coup the Day the Democrats Ousted Their Governor, is also for sale in the lobby, and I'm sure he would be willing to encourage you to sign it. Mr. Hunt will be assisted during the question and answer period from the floor by Professor Laura Daniel, Assistant Dean of the Jones College of Business, and Mr. Pat Embry, former Director of the Siegenthaler Chair in First Amendment Studies. So I turn the panel over.
Thank you. Well, so I'm the only one up here who went to MTSU, right? Mm-hmm. How am I doing so far? Okay. I want to say just a word myself about this panel, which is extraordinary. Also, how we're going to be using our time. And we're going to have, let me do that first. We're going to basically do three things. We're going to have, I'm going to throw a question to each of you, and we'll let your answer be the answer to that question, but also anything else you'd like to add in the nature of kind of an opening statement about Constitution Day, if you wish. But believe me, I got plenty of questions. So if anything, we're going to have not enough time this afternoon. But that's how we'll start in just a moment. Then we'll have some discussion and move through some of these questions. And we do want to allow time then finally for a period of time for your questions. I think at that point, all of us up here are going to be probably more interested in not so much my questions, but having a discussion, a conversation with you in the room in the time remaining. Okay? So the comment I'd like to make about this group, this is an extraordinary panel up here in front of you this afternoon. It's a distinguished panel, some extremely accomplished people, scholars in the law, people who have had different types of public service in their careers, I mean, you've got the bio sketches. What is in this publication here is but a sample. Now, it's a good summary, but these I would urge you to study the lives and careers of the men and women who are to my left. This is a very, very distinguished group that has agreed to come together and to have this conversation today and this week in observance of Constitution Day. I will also occasionally pull these out. I used to be more vain than I was blind, and now I'm blinder than I am vain, if you know what I'm saying. Okay, so let me then start. That's right. Let me start with Judge Daughtry, if I may. Just toss a question to you. It is Constitution Week, and we probably all enjoy conversations about the Constitution. My guess is that the general public understands what the Constitution is and is all about, much less than we might hope. And so I just wonder if you have a comment about, given your diverse career, different levels and jurisdictions, but about the Constitution generally. I mean, what's the one thing, Sissy, you would have us know about the Constitution so that we appreciate what it is?
Well, I would take a running leap over the fact that we have a tripartite system of government, and I might land back on the Bill of Rights.
Speaking of,
Exactly.
Right.
The First Amendment in action out there. I'm not quite sure what the sentiment is, but I have always been most interested in the Bill of Rights as that shining star, and more than just an asterisk on the Constitution since I went to law school. And it took a little time to get, I'm going to say, fully familiar with it, but nobody is ever completely and fully familiar with it. But if I had to vote for my favorite part of the Constitution, it would be the end.
okay, thank you very much. Let me go to Dean Wade. You have served, of course, at the highest level of our state judiciary, and you are a scholar of the law, as are your colleagues on the stage here. And, we've read a lot, Gary, lately, particularly since the election which Mary Evans referred to just a few months back. The whole subject area of executive orders, the legislature, its relation. It seems to me all of that has helped, to my mind, has helped kind of draw into focus the fact that there are these divisions, the separation of powers. And I guess how does that look to a sitting judge from the bench? What is the power of an executive order, short of its being challenged in a court? Or otherwise. To talk with us about that. How do these branches interrelate on a practical basis?
Well, I suppose that the judiciary would serve as the referee in the event of a dispute between the legislature and the executive branch on how effective an executive order is. Rarely, however, in the Tennessee Supreme Court did we address executive orders. I guess the most prominent regarding judicial retention in elections has to do with Governor Haslam's executive order, which basically places the merit system back into effect after a change in the Constitution in 2014.
Thank you. Judge Collier, we have read these past 9 months or so, if no other issue, the whole subject of immigration. And I'll just toss this to you. My question is, when we have discussions of immigrations, rules, laws, challenges, and so forth, What are talk a little bit about the role of the three branches in light of that issue and all that we've been seeing earlier this year. Not only the DACA issue and what's to be done with these 800,000 people, but more broadly, there's been executive policy that's been attempted and has been challenged with respect to limitations on folks coming to this country. From where you sit, and I'm not asking you necessarily to proclaim on one way or the other on the law, but how do we work through that as a country, given our constitutional system?
Well, the founders set up this government that they were creating so that the power of the government would be divided in three. And they also set it up so there'd be some tension between the three and competition. And there's also some overlap. The president will have some power. The founders envisioned that the Congress would have the most power. And in instances where there was a conflict between the Congress and the executive branch, the judiciary would step in. And immigration is one of those areas where all three branches have a very, very strong interest, and those interests will compete and conflict. And if there is not a resolution politically, then ultimately it will wind up in the hands of the judiciary for resolution, or there will not be a resolution. And immigration, as a lot of other issues we have not been resolved. They have not been resolved politically, and they've not been resolved in the judicial branch. So that leaves a lot of public tension and turmoil about the issue.
Mm-hmm. Thank you very much. Penny White, you have, like your colleagues up here, have broad experience in terms of the law and the courts and so forth and service. We hear people question or comment on the notion of boundaries, different ways to interpret the Constitution apply in terms of consideration of in cases, not just the facts in the law, but what does the Constitution have to say? And so my question to you is, how do judges know where to draw boundaries? There must be different schools of thought about that. Could you help us understand what the issue is?
I can try. We have two federal judges who would be much better at that, but I'll give it a whack. So when you ask Judge Daughtry her question about the Constitution, I agree completely with what she said, but I would add one point, and that is that the Constitution itself says that it is the supreme law of the land. But all it is a gathering of words, and those words have to take on meaning based upon various interpretations, as you suggest. And one of the struggles is whether those words should take on the meaning that they had at the time they were authored, addressing the problems of a fledgling nation, a new country, or whether those words should grow with the country and their meaning should change over time. And that divides very intelligent people. On both, very intelligent people believe that each of those points of view is the superior one. So very often that's why we end up, particularly if we look at the U.S. Supreme Court, who's the final arbiter of the United States Constitution, we have divided opinions because of different opinions as to how just the actual words should be interpreted. But I mean, that's a healthy exercise. That's what democracy is about. So for me, it's not one school or one other school, different. I believe that the Constitution is a living document, that it has to adjust as times adjust. Just for example, recently we confront all sorts of searches that weren't even thought about, searches of internet, searches of telephone devices that weren't even thought about when the Constitution was drafted. So there are others who just as strongly believe that the Constitution should be bordered, as you say, within the context of the time in which it was written. It's just a matter of various opinions.
Thank you. Thank you. Judge Gonzalez, could I ask you to speak to that same question? You have been certainly a judge. You've been U.S. Attorney General at the highest level of law enforcement, if I may, and that. But what would you have our students take away from this today, relative to the way in which? I mean, how should we understand when these issues come up of can the president do an executive order, may the court set it aside? I know this is a sweeping subject, but how do we who are lay people, maybe some here who wish to go to law school, but we haven't yet, so how do we understand these?
Okay, well, there's a lot to unpackage there. First of all, I'm delighted to be back at MTSU, and Constitution Day is a very special day as far as I'm concerned. Piggybacking on what's been said earlier with respect to our Constitution and what makes it special. You know, it's a relatively brief document, but it is just a document, as Justice White said, and you know, even Bolshevik Russia, I believe, as my recollection is, and Nazi Germany had a constitution. What makes our country so different is the spirit within our hearts of liberty. And so long as we have that flame burning within our heart, I think we'll always have a great country. So the Constitution is important, but it is a framework that guides the way that we live and guides the way that we govern ourselves. Separation of powers is a very complicated issue. It's a subject that I'm currently teaching. I taught a class yesterday in this area. And, you know, there's always been, as Justice White said, there's a tension. And I think that's a very healthy tension that we have in our system of government. And as I said earlier to a group of students, oftentimes issues relating to separation of powers are not resolved in the courts. Many are, but some are resolved in the political arena. If the president is taking on a popular issue, if the president is politically popular, if you have a Congress that's unpopular, if you have a Congress that has weak leadership, sometimes the president is able to take advantage of his inherent authority under the Constitution. So it's a difficult question to answer in terms of what are the boundaries of executive power, what are the boundaries of congressional power, what are the boundaries of judicial power. It's a question that's being answered every day as issues arise.
Let me throw out a question to the group, and anyone move to say a word about it, please do. I've read that Alexander Hamilton, the lawmaker, not the star, anyway. But when the framers of the Constitution created the judiciary, certainly in the context of the other branches, certainly, that he called the judiciary, quote, the least dangerous branch to the political rights of the Constitution. What did he mean, and what is your interpretation of what he said or wrote? It was in the Federalist Papers.
Having no power over the sword or the purse is the way he finished that. And there is truth in that. And he goes on to say that the judiciary merely exercises judgment. And I think that's why I compared this overlay between executive, judiciary, and legislative branch with the judiciary as being the referee. When called upon to make a call, whether it's an executive order or a piece of legislation that might conflict with constitutional principles, the court makes that call. And I was glad that Judge Daughtry mentioned the Bill of Rights, because perhaps the person that had the most to do with our United States Constitution's format and content was James Madison, who not only was the author of so many of the Federalist Papers, but also was able to use his political skills to bring those who insisted upon a Bill of Rights together with those who, more like the Hamiltonian approach, formulated the basic Constitution.
He was pointing out a key distinction between the judiciary and the other two branches of government. By saying that the courts only possess judgment, he also meant that our power with respect to people comes from persuasion. And that means that the courts must have credibility. The other two branches can operate without public support. And if you look at the polling results now, I think that Congress is somewhere around 18, 20% or so. And I think the president right now is in the 30s. And across the world and throughout history, there have been many examples of executives that have functioned pretty well without public support. And there are some examples of parliaments that have done the same. You will not find that, though, with judiciaries, that we must have credibility, we must have the support of the public. And when those conflicts arise with other two branches, if the public is not on our side, that means that the judiciary will lose. I'm told this is not exactly true, but there's a well-known story about John Marshall and President Jackson concerning the Indian removal. And when the Supreme Court had ruled, the story is that Jackson said, well, John Marshall has now ruled, let him enforce his judgment. I'm told that may not be accurate, but that's an example where when the public was on the side of the Congress and on the side of the president, then regardless of what the rule of law said, the rule of law may not prevail, because if the courts do not have the credibility and support of the public, then there's no sword, there's no purse, and we lose.
Is that to say there's no enforcement of a court order?
The enforcement comes from the executive branch. Mm-hmm. The judiciary has no enforcement authority on its own. We don't have an army, we don't have a police force. The marshals are actually part of the executive branch. And the enforcement actually comes from the credibility. So if we tell someone, you're facing 20 years in prison, but I'm going to let you out on bond, you're 50 years old now, and when you come back, you go to jail, you're likely to die in jail. They come back. They come back.
Sissy, did you have your...
Sort of. I was thinking when you asked the question about Justice Rehnquist's description of the court system in this country as the crown jewel of our government. And the truth is that the emerging democracies around the world have declined to follow our legislative and executive branches as models, preferring in many instances a parliamentary model instead. But there is a widespread universal respect for the courts, and it goes back to the independence of the courts, which is exactly what the Federalist Paper was aimed at. And it's a particularly important subject these days when we have got the executive branch actually showing a lot of disrespect for the judicial branch. The so-called judge tweet and the "he can't be fair because he's a Mexican" tweet and this kind of thing going on. It is hard to imagine how much damage that does among people looking at the court system.
Does everybody know what we're talking about? Got it? All right. Excuse me, go ahead.
No, that was just my point.
Sounds like we don't need to define our terms here much in terms of the news context of that point Judge Daughtry was making. Of course.
I think it's important to remember that particularly federal judges are giving life tenure in order to protect themselves from criticism. Sometimes judges get it wrong. We wouldn't have courts of appeals in the Supreme Court if the trial court judges always got it right. And so judges should, it's right in my judgment to be criticized of opinions if they're wrong. It's how you do it. There's a way to do it. You can be disrespectful. For example, I think it's more appropriate for a president to say something like, I respect the Supreme Court, and obviously we're going to abide by that decision. These are the reasons why I respectfully disagree with the decision. Something like that, I think, is a much better way to express your views about the work of the court. But it certainly cannot be the case that a federal judge, in particular a federal judge who enjoys life tenure, should be free from any kind of criticism, oversight, or any kind of review by others.
Well, I wouldn't say anything else but that.
Yeah.
On the other hand, it is necessary to understand that under the Code of Judicial Conduct, when individual judges or courts are criticized unfairly, they are unable to come to their own defense. And so one of the messages to all of you all is that if we're going to maintain credibility with our courts, when you see an unfair or untrue accusation or bullying being thrown at judges, if they don't come back with something, it's because we're not allowed to. And we are really dependent upon the bar associations and the lawyers and the citizens of this country to speak up and come to our defense when necessary.
Yes, ma'am.
Just to put it in perspective, federal judges do enjoy life tenure, but state judges don't. And 95 to 97% of the disputes in this country are decided by state court judges who, unfortunately, the majority of the states subject to elections. And you have
recall.
And recall elections and retention elections. And you are the only source of power for the judiciary to ensure that judges who are doing their jobs, who are acting independently and fairly adjudicating cases, although reaching unpopular decisions, are nonetheless allowed to continue to serve. So you as the citizenry really have a job to watch for unfair treatment of judges, particularly on the state court level. Because while the judges aren't going to be able to speak out necessarily for themselves, or if they do speak out for themselves, they're going to sound fairly self-serving, you are in a position to help, even as college students, and certainly as you go on as citizens in this country. It's very, very important. The legitimacy of the courts is completely dependent upon public support. And public support requires public education, digging down and finding out what the true story is, rather than listening to sound bites or necessarily looking at advertisements or other things that perhaps are for the purpose of manipulating your opinion about a particular judge or justice.
Okay, now we're talking. Okay, we're getting into some of the higher water around us at this time in our country. I want to throw, I guess, a two-part question to you all. And by the way, be thinking about your questions, okay, because we're going to get to that before you know it. These are seriously smart people here. I mean, absolutely. And it's really a privilege for me to
4 out of 5 is not bad.
Well, 4 out of 5, yeah. But it's not only an honor for me to be sitting up here with them, but it's a great resource that you have here on this stage on Constitution Day week. So be thinking about your questions, because we want to get to those pretty quickly now. What you just said about this makes me remember that from time to time, I guess all my life, I've heard people teachers say that our U.S. Constitution, our Bill of Rights, combined, is a living document, is a living, breathing document. Now, the first part anyway, is do you buy that still? I mean, is this document from the 1700s still applicable and workable in our current age? And related to that is what Penny just said about and Judge Gonzalez and Judge Daughtry, about when the court is criticized. We have to, seems to me, we have to acknowledge that we live today, better or worse, in what I would call a hyper-partisan age. I might call it an angry age, and we don't all have to engage in that kind of behavior, of course, and thanks be to God, most of us don't. But yet we do in terms of our national discourse. So with all of that together, I'm wondering, what is your feeling, your understanding, knowing the law as well as you do in the Constitution? Is it really still a document that is suited to our current age? Who would like to go first?
It's hard to reduce the work of the judiciary to sound bites. And don't we all today look for sound bites?
Yes, sir.
And tweet is a good example because we're so limited in what is said. But during one of the Judicial Evaluation Commission meetings, someone asked me if I subscribe to the theory of original intent. And my question back was, how do you define original intent? I think it's important in any analysis of a legal issue to think about what our founders originally intended, but it's applied to new and different circumstances. So you can call yourself one or the other, but I think the tendency as a judge is to look at both. I mean, we didn't have tweets in 1789. We didn't have a telephone, as Justice White has pointed out. So many things have happened over the years.
By the way, telephones that had our entire life.
Yeah, that's right. But the long and short of it is that it was always hard for me to describe my judicial philosophy as either original intent or living and breathing, because you could pick one or both and end up at the same place.
Yes, sir. Thank you.
I think it's important to remember that the Constitution does not say how it is to be interpreted. So we begin with that problem. It's a very serious issue. And I think there is a difference of opinion, and this is particularly true between the parties, political parties, about what is the appropriate way to interpret the Constitution. You're right, we should not be governed solely by a document that was drafted over 200 years ago. But from my perspective, you begin with the text of the Constitution, the words of the Constitution. It provides clarity. It provides predictability when you look at the words. And it is true that the framers could not have anticipated the technology that exists today, which is why they included the provision relating to amendments to the Constitution. The issue that I have about constitutional interpretation is, it seems to me that, particularly with respect to the creation or establishment or finding new rights, I worry that we have 9 unelected judges do that. I'm not saying that those rights aren't important, say the right to privacy. I think it's vitally important. I just believe that the framers intended that for something like that it be established through the democratic process, through the constitutional amendment process, as opposed to having 9 unelected judges make those kind of determinations. So there's something that's not controversial for you. Have at it.
Yes, sir.
Well, I would say in response that it's not just 9 unelected judges, because those cases come up from the trial courts into the intermediate courts.
But at the end of the day, it's those 9. You know that.
Well,
They have the
can't.
final say.
They do have the final say, but it's not that it hasn't been kicked around where and discussed and views come out. It's not, they don't just walk in out of the wings and decide those cases.
Yes, that's right.
The founders, when they adopted the Constitution, was not writing that document just for the people in existence then. They were writing it for future generations. And they understood there would be things that would be happening in this new nation that people alive at that time could not contemplate and understand. So that's why it is full of generalities. Equal protection, that's in the Fifth Amendment. What does that mean? I was born in 1949, and I started school 2 years after Brown versus Board of Education was decided. I went to an all-black school, a segregated school. 12 years later, I graduated from that same all-black school. My sister, who was 2 years younger than me, graduated from that same school, all black. My a brother, 2 years after that, graduated from the same school. Those words, equal protection, they're the same words, but as time goes on, you can look at those words differently in the context of which you are, and arrive at a decision that is fitting and more suitable for the time in which you live. And I think the founders understood that was going to happen. I don't think they would be shocked or surprised that those same words are being interpreted differently now than they were 50 years ago or 100 years ago or 200 years ago. They were very, very bright people. They had studied human behavior, they studied government systems around the world, and they understood that things happen in societies.
Well, then, how do you fit, each of you, if I may, let's take the issue of congressional redistricting, reapportionment, and so forth. That's an issue that's getting, to my eye, an increasing level of attention on the part of folks who would like there to be a different type of election, not with respect to political parties per se, but that that there might be a fair choice. And if you, I was doing a little reading about thinking about this discussion, and the notion of redistricting came to mind, and I looked up, and if you will go online and look at the state of Illinois, I went to school there, state of Illinois, Congressional District 4, and this district has been so gerrymandered, it goes out the Eisenhower Parkway and it comes up through Naperville and it goes back in toward the lake shore, and seriously gerrymandered, and so people say, well, there's, and I believe there's a pending case about this before some court, and
Or two.
people say, well, but that, or the courts, I think traditionally have said that, well, that's a political question, and sort of hands off. I'm wondering what your thought is about the currency of our Constitution relative to an issue like that does seem to be a very pressing one, and yet it's not fixed.
Well, I'm not going to speak too much about that because there's a possibility that a case like that could come before me. But let's think about where the word gerrymander comes from. It comes from a man named Eldridge Gerry. I believe it was Massachusetts.
Yeah, I think you're right.
What year was it? 17? So that
I was
has
there,
been,
but I can't remember.
that has been a part of our political system from the very beginning. It has been there. What has changed is technology. It used to be that people, based on their experience and a lot of other people working in the precincts and whatnot, would try to draw up a district that they thought would be suitable for them. But now with these computers, you can do things that are so fine-tuned that you can pretty much guarantee the results. So what was a problem before, and from the court standpoint, it's very difficult for the court to articulate a standard that was easily understood and applicable. Well, now you have computers that are doing things, and it may or may not be possible using computers again to come up with a different way of doing things. But gerrymandering has been around since the country has been here.
There will be a spelling test, gerrymandering, okay? We'll come back to that. Any other comments about that?
Well,
Pretty hot
I
issue.
think it's, I think it's a very hot issue. I happen to think it's the reason that Justice Anthony Kennedy didn't retire last year. There was a lot of speculation that he was about to retire, but he's very interested in it himself, and he isn't hiring law clerks for a year from now, but he will be sitting on the case or cases. Have they consolidated those that are coming up before the court?
I think they will. I don't know if they have or not, but I'm pretty sure they will.
In this term. You know, you would think here in Middle Tennessee that you might have a district that would take in all or part of Nashville and maybe all or part of something close to it like Franklin. And instead what you have is Franklin in a congressional district that runs down I-40, I think, and takes in Germantown down outside Memphis. Somebody may
There you
be-
go.
Yeah, somebody may be in the name of one man, one vote, which the court has already ruled on, might say there's something about this that doesn't look entirely fair.
By the way, the Baker versus Carr case that led eventually to what we call one man, one vote originated in Tennessee. As I understand, it actually came up from maybe Chancery Court initially in Davidson County. I'll pull this into a little closer relationship for us here. I was talking to Congressman Jim Cooper, Congressman Cooper of Nashville, Democrat. He told me the story after, I guess he served in two different districts and so forth, and a very distinguished member of Congress. He's told me a story about, I guess, after the 1990 census and then 92, the redistricting at that point came up. And he, and by this time, the Republicans, not his party, were in charge of the legislature.
Right.
And I may have the year wrong, but anyway, and the first thing he knew, they had redrawn his district, And it consisted largely of the Davidson County voting area. But then this one map that was created by computer, as was mentioned, extended out Interstate 24 to Murfreesboro, because there was a concentration at that time, maybe still, on this campus of Democratic voters. Well, the Republicans drew that map, and he said it was called the University District. Now, this never got accepted, it was not approved. It was officially called the University District, but Cooper and his people called it the ET District, because there was it was a finger that came down, and it sort of ballooned out down here at the bottom. So this is what we're talking about. Now, not to take us all exclusively on the issue of redistricting, but be thinking of your questions, okay? Let me move to just another aspect there.
But before you leave,
Yes, sir.
let's make one point. What we've been talking about here is political or partisan gerrymandering, not racial gerrymandering. Racial gerrymandering has been condemned by the Supreme Court and also by Congress, and the courts have a very, very strong role to play there. And the word gerrymander covers both of those, but one is very different from the other.
Yes, sir. Thank you. Thank you. Let me shift to a different aspect of this. There are, of course, different kinds of courts. There are federal courts, there are state courts, there are municipal courts, different jurisdictions and responsibilities. With respect to state courts, in particular, we've got a couple of three of our panelists who have been up close and personal on the questions, or with the questions of how are judges selected? How are judges deselected? How is a judge replaced? And so all of that is sort of that big rambling sentence I just said involves a lot of different procedures. In Tennessee, we have maybe still a kind of a peculiar system, the modified Missouri plan. Now, you can correct me if I'm not current there, but the means by which a prospective judge is appointed, confirmed, and Justice Wade, you have been this recent, prior to your retirement from the court, Tennessee Supreme Court, you were up close and personal with that, and the campaign about shall we change the policy in our state. Would you tell us a little bit about that?
Well, the modified Missouri plan evolved, I think I would say, rather than devolved, into the Tennessee plan, which was designed to have merit selection for appellate judges, and merit being based upon the skill and knowledge of the prospective judge rather than the political leanings of that judge. And I think all of us would agree, in an ideal world, the judges never wear the label of a Democrat or a Republican, because, again, they're called on to be referees and decide disputes between the Republican Party and the Democratic Party. But more recently, the plan was changed by amendment shortly after the August 2014 election. And what Keel is talking about is that the Speaker of the Senate in February of 2014 decided to make a partisan challenge to the three judges on the Tennessee Supreme Court that were up for re-election. And he did it in two ways. First, the Supreme Court and all appellate judges are evaluated by an independent evaluation commission. Basically, we get a grade card, and if you pass, you get to be on the ballot on basically a yes-no basis. And the two-pronged attack was first to do away with the legislation regarding the terms of the current evaluation commission members so that one party could name them all pre-election. And then the second was just a straight-on challenge to the three incumbents, all of whom had been appointed by Governor Bredesen, thus by inference were Democrats. and because the legislature is predominantly Republican now, that and the theme of the party was red to the roots, that Speaker Ramsey felt like it was important to have members of his party hold every office. And so he developed a well-funded challenge to defeat all three of those individuals on the ballot, including yours truly. Fortunately, he was unsuccessful. And I think the people of Tennessee, and especially the bench and the bar, that insisted that partisan politics should play no role in the selection of judges, prevailed. And that was a strong message for the people of this state, I think, favoring an independent judiciary. And when I say independent, I mean not beholden to either the executive branch, the governor in our state, or the legislature, and that thus they were in a position to make calls without a lean in either direction.
You know, you might add to that discussion the fact that in Tennessee, the trial judges are all still elected. The reason these merit selection plans came about was because people don't know the appellate judges that are on their state Supreme Court or their intermediate court. They may be familiar with the judges that are local or municipal, but so something was proposed that would inspire a little more confidence in who was sitting on the higher court benches, and that's really how it all came about. I hope we're going to get into a discussion about how the election of judges at that level has devolved into some pretty unfortunate campaigns and elections, because the picture that we've got now is not good.
Can I?
Yes, sir.
Go ahead, Justice. Go ahead.
If I could add
Justice White.
to I don't really guess it's a counterpoint of view, but it kind of is. We lost in this state in 2014 by the passage of that amendment. We lost a crown jewel of a judicial selection system, in my opinion. I've written on this several times, so it's nothing new to anyone who follows what I write. And we lost that system to politics, and we lost what was a unique aspect of the Tennessee appellate judiciary retention program, and that was judicial performance evaluations. Justice Wade referred to it as a report card, but when the judicial performance evaluation system was originally drafted in 1994, Justice Bill Koch and myself, he was a judge at the time, I was a justice at the time, we chaired that committee, and we were the 8th state in the country to give judges an opportunity to be evaluated based upon things that matter to judging, the criteria that the American Bar Association has designated as important to judging. And that was a multifaceted evaluation system that allowed judges to evaluate other judges, jurors to evaluate judges, court clerks, lawyers, and it was several years in the making, and it had great potential. It never had the resources it deserved, but it had great potential. So we went from being one of those states, one of 8 states, and then eventually got to be 11 states with JPE, Judicial Performance Evaluations. We went from that to a system now that you are back in the position of not necessarily having the information that you need to determine whether John Jones should be retained or should be elected on the bench, because that kind of data is no longer being kept. So we lost, in my opinion, a beautiful, well thought out system with the passage of that new amendment, and it has the potential to drastically change the face of the judiciary in this state, in my opinion. And I've done them all. I've run in a heads-up election in a 1,400-mile judicial district with no party label and having been not involved in politics at all. I've run in a retention race where I wasn't even in the United States on the day of the retention rate and got more votes than anybody on the entire judicial ticket. And then the race that I really tried to run and win on the retention race, I lost. So I've experienced each of those different types of elections, and and feel concerned about the potential for the politicalization of our judiciary in the state of Tennessee.
Well, Judge Gonzalez, if I could ask a quick follow-up, Justice White, but to me the quandary has to do with the fact that the work that you do as judges is so complicated. It involves legal, the law, the Constitution, legal theories, and so forth, and competing interests that need to be reconciled, of course. But how do you have a suggestion for how the rest of us can become informed, better informed? I'm not trying to put the be necessarily on
This
you.
is one great way.
But I'm sorry.
This is a good start.
Yes, sir.
And of course, as Justice O'Connor has said since her retirement, it has to start much earlier. It has to start in the 2nd, 3rd, and 4th grade with civics education. But you know, lawyers, a lot of lawyers are leaders in the community. They go to church, they go to civic organizations, they talk to people, they talk to their family members, and I think it is highly it is complex. But the skills of good judging, you don't measure by the decision of the judge. So it's not how the judge came out that should impact whether you think that person is doing the job of a good judge, in my opinion. Certainly you don't want someone who misapplies the law consistently, but there are a host of factors, what's the word I'm looking for? Dignity in the courtroom, treatment of litigants in the courtroom, familiarity with the law, decorum in the courtroom. There are a lot of factors that go into whether someone is judicious in their behavior and a good person to serve as judge. Sorry.
To follow up, I mean, in most jurisdictions, you do have the local bars. They do have the bar polls. They poll the lawyers. I'm not saying you should always trust the lawyers and the bar polls, but you do have that as a source of information. Oftentimes, newspapers will make endorsements. Again, take that with a grain of salt. I ran in 2000 a statewide race in Texas. Texas is a pretty big state, so I had to go out and raise about $1 million, and that's when $1 million really meant something. In 2000, and it was unpleasant. I didn't like the fact of having to go to companies and organizations that would likely have cases before the court. I hated it. I went to Governor Bush and I tried to persuade him, please try to champion an effort to change our system. And his standard answer was basically, it's hard for me to go to the people of Texas and take away from them their rights to choose someone in their government. So I never got very far with that. But I don't like particularly partisan election of judges. I think it's a bad thing.
Well, that's part of the problem we've got around the country now. It goes back. I used to be a First Amendment fundamentalist. That may be because, I don't want you to take this the wrong way, but that may be because I slept with the press for 53 years. My husband was a political reporter for the National Tennessean. And so he and John Sigenthaler and Keel Hunt and a few of that ilk had me pretty well convinced that First Amendment rights were absolute. And then along came a case called Minnesota Republican Party versus White, and I'm sorry I'm blanking on the year. And what it said was that the provision in the Minnesota Code of Judicial Conduct that prevented judges and judicial candidates from taking a position on issues that might come before them was a violation of the First Amendment. And up until that part, none of us out campaigning ever took a position on some kind of, I remember going around in the fall of 18. Whoa. Oh, but not that old.
I was right with you.
1989, and campaigning on the need in Tennessee for an administrative office of the courts and for ADR. And one of my colleagues-to-be, who was campaigning behind me, said to me at some point, "What is this thing called ADR?" He said, I'm trailing along behind you and everybody wants to know what my position is now on ADR. And what is it? Well, we've got ADR. We've got a spectacular administrative office of the courts now. But that shows you that that the campaigns used to be fairly bloodless. And then along comes this Supreme Court opinion that says that judicial candidates and judges can be backed into a corner, in effect, and forced to take a position on issues that might come before them. And, you know, that fall I was going around, people wanted to know not what my position on ADR was, but what my position on the death penalty was. And unfortunately, I was able to say back in that day, I'm sorry I can't take a position on that because those cases may come before me. If I couldn't have said that, I might well have lost an election, as Penny White did, over that issue later on. So having said that the announce clause in the Code of Judicial Conducts, those codes all over the country, didn't mean anything. And then if you pile on top of that Citizens United, which said that any amounts of money, not necessarily transparent donations, can go into these races, and now what you have is $1 million won't get you in Texas anymore, will it, Judge? You've got to raise many more millions than that. And you've got, the worst of it is outside groups, special interest groups, coming in and funding these elections and funding them on the basis, I guess I don't want to take up too much time, but the sterling example was in Wisconsin a few years ago, where one of the incumbents on that court had always been considered one of the top-notch high courts in the country. And they had their first African-American judge on there, Louis Butler. And a law and order trial judge from a very small county in the northernmost section of Wisconsin ran against Justice Butler with a bunch of money, and they came out with, how many of you know what the Willie Horton issue was in the presidential elections back in the 80s? Raise your hand. Does anybody? A few of you.
Good number.
Yeah.
That happened before most of our audience was born.
Sorry about that. Anyway, what happened was the television ad had a picture of Justice Butler, who was black, next to a convict who had been convicted of rape. And the implication of what was running under those pictures was that Butler had gotten this guy off on a loophole, and that he had gone out, the convict had gone out and committed another rape. Well, none of that was true. In fact, what had happened was Louis Butler had been a public defender earlier in his life, and he had represented somebody who had committed a rape, or who was at least convicted of committing a rape. And so he lost the case, and his client went to jail, served his sentence, was let out on parole, and then committed another crime. So the implication was absolutely unsupported in every fashion that you can imagine, and that ad ran and ran and ran and ran. And the upshot was that Gableman, the challenger, won the election 51% to 49%. And it is emblematic of what has been happening around the country that is very harmful to the independence of our courts, because people then feel like they've got to toe the mark, or else this, what we're calling now dark money, comes in from out of state and just swamps them.
But to put it in a little bit more practical terms for all of us, there's incentive now for someone who's running in a state system and challenging a judge to speak to a group from the insurance industry and suggest they'll be friendly to the insurance industry if they take the bench, or someone who's in favor of law enforcement, that they're going to be tough on crime and they're going to sentence people to very harsh sentences. Well, with the rule of law, judges are expected to look at each case separately and to be influenced by facts of that case and the law. But if you've been making public statements to people that once you take the bench, you're going to be friendly or unfriendly to certain spectrums of the society, then how can people have confidence in the court? So the threat is that by allowing people or forcing people to take positions in advance on issues, that the people will not give the courts credibility when they reach a decision. Was this decision based on the rule of law, or was it based on the commitments that that person made before they were elected?
3 quick points for voters. If you see an ad on television, and I brought about 50 of them with me, but we aren't set up for that. But if you see an ad on television that looks pretty horrific, look to see who paid for the ad. Sometimes ads are run by special interest groups without permission of the candidates. So it may be run by someone who's trying to impact your thinking about that candidate. Number 2, if you see a questionnaire that says, Judge so-and-so answer the following questions in this way, and you see a judge's name who did not answer, remember this conversation. What that judge who did not answer is saying is, I refuse to stand up and make a blanket statement about how I feel about an issue unconnected to facts in the case. Instead, I'm going to apply the rule of law. So I said 3, but I'll leave it with those 2. Those are 2 things voters can pay attention to. Who's paying for the ad, and what is the motivation of that group that's paying for the ad? Do they really care about crime, or is their motivation to get someone on the bench who will maybe listen to their business interests? And then secondly, if judges aren't speaking out and telling you their opinions, it's probably because they don't feel that that's the role the court should play. It doesn't mean they're hiding anything from you necessarily.
No office, no matter how high or important, even in the judiciary, is so important to forfeiture integrity. And Keel, I'll plug your book because he tells a compelling story about a governor in the 1970s that had basically used his office to fill his own pocketbook and did so without any principle whatsoever involved. And when the Democrats were in charge in those years of both the House and the Senate, leaders of the House later became governor, but the Speaker was Ned McWhorter, and the Speaker of the Senate, Lieutenant Governor Wilder, joined together on a nonpartisan basis to swear Lamar Alexander in as governor early in order to avoid corruption in the Board of Paroles. And the compelling comment that Keel points out in that book is made by Speaker then, McWhorter, who, when confronted by the news media, said, "You're a Democrat. Why in the world would you side with a Republican to get that Republican sworn in first?" And his answer was, "I'm a Tennessean first." And to me, that demonstrated the kind of courage that all of us should expect in our public office holders, and especially within the judiciary, because the judiciary is called upon from time to time to make decisions that are not popular to the general public, but are compliant with the rule of law. The rules of law can always be changed. There's a process for that in the Congress or in the General Assembly on the state level. But the courage of the individual in holding that office is what really separates the wheat from the chaff.
And Keel, this is such an extremely important point here. Cheaters will always have an advantage, but that advantage should be as short as possible. And it's incumbent upon the citizens at large, civic groups, and even the political parties to do as much as they can to either prevent cheaters from prevailing, or they do prevail, to make their victory as short as possible. Someone who's willing to stand up in front of a crowd and make promises that they're going to do something when they take the bench, they're going to take money from people to do things, they've got an advantage there. But there has to be some mechanism to make that advantage short-lived.
Thank you, sir. Let's do, what I'd like to do now is let's see what questions you have. Now, the way we're going to do this is we've got a microphone here at the head of this aisle, and we have another one right over here. And I would much rather hear your questions than mine. So just come up and we'll see. Thank you. I want to say, come on down, you know. Well, while we're coming up, I might say I appreciate Justice Wade's reference to my book. The title is The Coup. The title came that close to being what Ned McCordis said that evening of the coup, and when he said, "First, I'm a Tennessean." That's what these people were. Okay, so let's start here. Okay.
Hello, my name is Tess, and I am a junior English and Spanish double major, and I have a question for Judge Gonzalez. How does it feel to know that you legally authorized the CIA to perform what the United Nations describes as inhumane and degrading forms of torture, such as waterboarding and sleep deprivation?
Oh, gosh.
You know, I long ago tried to, or stopped trying to defend what we did in defense of our country. All I can say is that the lawyers throughout the Bush administration, not just Al Gonzalez, but working primarily with John Ashcroft, who was at the time, the Attorney General, we did our very best to advise the President as to what he could legally do to protect our country.
Hi, I'm Amy Sayward. I'm a professor of history, and I was especially curious. The death penalty has played an important role in the work and the careers of everyone here on this panel. Certainly, U.S. Supreme Court Justice Harry Blackmun, in his '94 dissent in Callins versus Collins, said, "From this day forward, I shall no longer tinker with the machinery of death, declaring that the death penalty experiment has failed." After 23 more years of tinkering, what is your opinion about where we are on the death penalty and the judiciary currently? Thank you.
Well, every year, the polls show that citizens in this country are less and less enthusiastic about the death penalty. I have to say, one of the reasons I took senior status several years back was so that I could notify the clerk that I would not be sitting on any more death penalty cases. So I feel unencumbered about speaking right now. Those issues will not come before me anymore because I'm not sitting on the cases. I don't know how many of you realize the Blackmun thing is good to bring up, because the truth is that on any given morning, one of the justices of the Supreme Court who is supportive of the death penalty could wake up and look in the mirror while he's shaving in the bathroom and say to himself, you know, we fooled around with this enough. Next one, I'm going to change my vote, and it would be over. Just exactly like that. Now, do I expect that to happen? I have no idea whether that's going to happen or not. But that is the truth. That is how close we are now to seeing that the death penalty is ended. And as less and less support among the voting populace is apparent for the death penalty, I think it's probably on its last legs. I'd be interested to know what other people think.
You know, the U.S. Supreme Court is not the only body that can right this situation, as long as we're dreaming. The Tennessee General Assembly, the Tennessee Supreme Court is also in a position, and the trend in the states has been toward either issuing moratoria with regard to the actual executions, either because of a drug shortage or because of a fear of innocent people being executed. So that's the trend. So we can't get it right. You know, I want to say just one thing to back up a moment. You never come to terms with what you can and cannot do as a human until you face it. And I honestly believed when I became a member of the Supreme Court that I could affirm a death sentence for an individual. And if I ever had the opportunity to be on the court now, I would know I cannot. So I have become informed over time. And for me, it's not an issue with regard to personal opinion. It's the fact that we are human and we cannot get it right. And we do not invest enough resources to assure we get it right. So we have some great capital lawyers, but we have, sorry, Judge, We have Joe Cannon, who sleeps through capital trials in Texas and still gets reappointed, and who the Fifth Circuit, do I have my circuits right, cannot agree is ineffective, because after all, the Sixth Amendment says you have a right to a lawyer, not a right to a lawyer who happens to be awake during the case. So as long as we're going to play those kind of games and just appoint a living, breathing, sleeping body to represent people who are facing the ultimate sanction of the state taking their life, we can't get it right. So I hope Judge Daughtry is right, but we have a state, we have citizens in this state who could have their voices heard by the legislature in this state, and we could be one of those states that says we're just not going to do it anymore. It's not just the states that you might think of. I mean, a state in the Union who hasn't had the death penalty for close to 150 years is West Virginia. West Virginia's never had in recent times has not had the death penalty. So it's not just like a California kind of thing. In fact, California's got the largest death row in the country, but for obvious reasons. But it is something that we could urge our legislators to do as a citizenry. So my soapbox, I'm off.
Thank you. Let's go over here. We're not going to go past 4, as I understand it, and or else I, for one, am going to need sunscreen. These are very impressive lights up here. Right over here.
Hello, my name is Dalton Slatton. I'm a pre-law student here at MTSU, and our generation is known as being very polarized and very opinionated and emotional. So looking forward to one day when I hopefully sit in one of your esteemed seats and on this. What can you tell me about whenever I would get to that position, how to be unbiased and just follow the law besides incorporating my own personal opinions in the law? Thank
Well, I grew up in the 60s, and we, of course, were not polarized in the 1960s.
I think the first thing you have to do is, of course, recognize that you have biases. You have that could, in fact, influence the way you interpret the law, the way that you do your job. I think the good ones understand that. I'm not saying that people don't have it; they do, but the good ones understand that. They're sensitive to that in making their decisions. They try to be as passionate about it as possible, and the good ones can do that. You know, so that's the thing. You just got to be aware of the fact that you do have biases and deal with it.
One of the things I would suggest to anyone who has some interest in going to the law is read as much as you can. Read about the history of not only this country, but also other countries. Read philosophy. Read great books. And you learn about human nature from reading that. And then look into yourself. We're all infallible. And we don't have all the answers. And it's important that you open your mind to others, because they may have answers that you don't have. But grounding yourself as much as possible and a broad base of reading is a good thing.
One of the things that has improved the courts, I think, if you go into a courthouse and look at the pictures of the benches, what you'll see is dozens and dozens and thousands of old white men. And that's what was
I'm
there.
going to take that personally.
Yeah, you better. Especially with the hair having gone. It's gone.
Well, I see you've joined me.
And we, no, this is blonde. This is gray.
These are blonde highlights here.
That's changed. I'm not going to get on the soapbox about that, but it wasn't so long ago that there really would have been sort of only one view of whatever was in front of you pertained, and now we at least have some diversity on our courts.
Right here.
Good afternoon. My name is Bailey Nemeth, and I'm a criminology and criminal justice student here at MTSU in my sophomore year. And Judge White, I'll address you, but I'll pose my question to the entire panel. Well, speaking on a point that Judge Daughtry made, the two of you said something along the lines of that it is the duty of the people to stand up for the unfair treatment of judges, as you cannot do it yourself. So with the way that students and young people of our age group are deemed in today's society and media as these kind of uneducated, whiny millennials, ungrateful, how do we begin to have a voice that the rest of the country will take seriously? Thank you.
Well, I wouldn't characterize, I'm a teacher, so I hang out with people your all's age every day, and that's what makes me happiest, is being in the classroom with 22 and 23 and 24-year-olds. So So I don't know about the whiny, et cetera. You are savvy. You have as Judge Collier just said, you have the ability to be better informed than any generation before you if you just get off those dad-blasted Facebook pages and cell phones and download books or go to your local library. You have at your fingertips the ability to be the most informed generation ever. And I think knowledge is power. And so youth, it can sometimes be a detracting, people may not take you as seriously because you're young, but knowledge and facts give you power. And so I think just doing what you're doing. You're here today. It's a beautiful afternoon. You're in this building listening and asking questions, and you're in criminology, so you care about that system. So simply just remaining involved and active and taking the time to learn and ask questions just like you're doing. I mean, it seems like a tried answer, but it's from the heart.
Could I give her a homework assignment?
There you go.
Sure.
Do some research and find out what the average age was of the signers of the Declaration of Independence.
Good point.
Yeah.
Good point.
Okay. These are great questions. Right over here.
My name is James, and I'm a dual major, political science and history. And my question is, if we were to have a constitutional convention this year, God help us, is there anything you would change about the way the judiciary is formed?
Not me. I managed to get through the hearings and the confirmation, and there's actually a sarcastic takeoff song called Judge for Life, and it's pretty cute. You can Google that, and I'm happy with it. There are people, however, who think we should have term limits, maybe staggered term limits, and there have been proposals for change. I think the system is pretty close to perfect as it is.
I don't know if I'd say it's perfect, but my sense is, like any other major change that would require an amendment to our Constitution, it's going to require some kind of crisis or scandal first. Otherwise, it's just too hard to change it, as far as I'm concerned.
You're undoubtedly right.
I would be very much opposed to a constitutional convention. Remember, the last time we did it, all of the attendees disregarded the orders from their states, pursued something that they'd not been authorized to do, and produced a product that nobody had asked for and everybody was opposed to. And we have the Constitution now, so there's no telling what might come out of a second constitutional convention.
Pat, are you trying to ask a question? No.
They told me I didn't have to work here today.
Yeah, right.
So
You look real good standing there. Okay, so right over here. Yes, sir?
Hey, I'm Chris Kelly. I'm a political science major. There's been a lot of talk about America not ever being great. People say that the Constitution was built on oppression, that it was built on democracy for white men only. Other people would counter that by saying that there was implications that the Founding Fathers made it to be not a straitjacket, that it was a flexible document. How do you respond as true believers of the Constitution? How do you respond to people who say that it's a document of oppression, that America was never great? How do you respond to that?
Good question.
I think America has always been great because of its Constitution. And at the risk of possible intrusion, I would say that our country continues to be great because of our Constitution, and there never has been a time when it wasn't great. We have evolved. There were times between 1789 until President Lincoln freed the slaves, and until the early 1900s when we had women's suffrage, that were bad times for America. But it's look at where we are today. As Justice Daughtry mentioned earlier, our country is envied by all for its judicial system, and our judicial system is derived from a constitution. So there's good reason for all of you to gather today to celebrate the world's greatest Constitution, as is imperfect as it can be from time to time.
Thank you.
You know, you have to sort of take yourself back to what was going on when the framers of the Constitution came up with this. I mean, think what else was going on in the world that was simply awful, and yet that group of men was able to come together and create this document and create this system, something that the world had never seen, had never known. It's really remarkable. And, yeah, there were mistakes in there. Gary's listed a couple of really, every time I hear somebody talking about the original intent, I think about women not voting and slaves, black people counting for 3/5 of a person, and I just get frantic with anger about it. But you have to put it in context, and in context, it was a remarkable thing to come up with at that time in the world. I hope the history teachers around that are here today will agree with me.
And we haven't stopped. I mean, this morning's news story was about to what extent the Equal Protection Clause stops employers from firing people who are in same-sex marriages, or people who are outwardly gay, lesbian, or LGBT. So 20 years ago, when I was a lawyer and a case like that walked in the office, I would say, I'm sorry, there's no constitutional protection for you. But those issues are pending in the courts, and by the time you're out practicing law, those of you who want to go to law school, those issues will have been resolved, and my guess is that they'll be resolved in favor of equal rights. And so you're still looking at that same document written by those early forefathers that has evolved to be a safeguard in our time. So I have to agree with Justice Wade. There's a lot of times I criticize the country, but it's great to be, I almost said a Tennessee Vol, but I'll say it's great to be an American.
One of the things that we do in the district court is to preside over naturalization ceremonies. And I have done that since I've been on the bench, and the demand is so much now that we have at least one ceremony somewhere in the district every single month. And we'll have people from almost every single country on the face of the earth becoming United States citizens. And they sit out there in the audience with American flags. And when you announce that they're now citizens of the United States, the entire family breaks out in tears. That has been the story of this country. Except for blacks, every other group of people that came to the United States came here escaping something. They're looking for freedom. It may have been freedom of religion, it may have been political freedom, it may have been economic opportunity, but they saw this land as something much, much better than what they were leaving. And they also saw this land as a place for their children and their children's children to progress. Were the founders perfect? No. Was the Constitution perfect? Of course not. They were men, and all men make mistakes. Always have, always will. So if you're looking for a perfect document, you're not going to find it in the Constitution. You're not going to find it in the founders, but you won't find it any place else either.
I can't think of a better way to end this program than what these people just said. You've been a great audience. Let's give thanks to our panel.
Thank you. Perfect. That was very perfect English. Couldn't explain that better.
We're so thrilled to have had them here, and we want to ask you all to stay, come down, shake their hand, meet them, ask them your questions personally. We're going to have a little reception for the next hour. Would love to invite you to join us. Thank you very much. Happy Constitution Day.